to the administrators. So such assets are now at the risk of being forfeited to the federal government. And then you have the fourth class. And that fourth class, I want to believe that this proclamation or court order was meant for them. And these other three classes will now suffer collateral damage.
Well, you haven't mentioned this fourth class, but a lot of people, of course, says it's targeted to the political class. So, and for them, why wouldn't this be directed to such accounts rather than including some of these people you have just mentioned?
Well, that's why I said that the policy or the court order was targeted at a particular class. I wouldn't even use the political class. Some of them may not be politically exposed people. They may be a majority with politically exposed people. But you have people who are engaged in illegal transactions, who the balance they have are proceeds of illegal transactions, and therefore do not want to be identified formally with those balances. And I think that's the target that should ordinarily be the target of the policy. The questions are this. The existing rules and regulations guiding the banking industry, Nigerian Financial Intelligence Unit, Money Laundering Act, stipulates that certain transactions are classified as suspicious transactions. When a transaction is classified as suspicious transaction, the financial institution is required to render returns to NFIU, that's Nigerian Financial Intelligence Unit, indicating that these transactions are suspected as suspicious. And then NFIU, which is currently under the Economic and Financial Crime Commission, will investigate that account and determine whether the balances or the transactions relate to illegal transactions or proceeds of illegal transactions. And if that be the case, the law allows the government to forfeit, to take over such assets. They have the right to forfeit such assets because if you have proceeds of illegal transactions, you cannot be allowed to enjoy it. So if the target is those people, then we should be able to discriminate or differentiate between the small-time depositors who have 5,000 here, 20,000 here, 50,000 here, and those balances. And for me, first thing you can set a threshold. Let's assume 5 million, for instance. A threshold of 5 million, and say, look, balances above 5 million and above that do not have BVN, you are required to move those balances to a suspense account with the central bank and publish the names of those account holders and give them 3 months or thereabout to come and make proof that the accounts belong to them. Otherwise, you cannot forfeit them. They cannot forfeit them. I think that's where we should start. The issue of forfeiting assets, because you're dealing with property rights, it's not something you do in a hurry. And particularly if you have a blanket forfeiture of accounts that are not suspicious transactions.
Right. Okay, now, with this court order now, if these monies are frozen, where would they go to? To the central bank or to the banks?
Well, you know the court order was obtained by the Minister of Justice. The only way they can go to, the balance will go to is central bank. They will not, they have asked the banks to render returns to central bank of those balances. The next thing is that when you talk of permanent forfeiture, the forfeiture will be forfeited to federal government account. And federal government accounts are domiciled with central bank. So the monies will ultimately go to central bank.
Okay, so what would be the implication of all of this? I mean, with this order now, for diaspora funds, we're trying to encourage Nigerians outside the country to bring back their monies. For financial inclusion that the CBN has actually been preaching about.
Okay, I will take it from the two perspectives you came from. The issue of diaspora funds. The active diaspora members don't have a problem with the BVN. Those who are doing transactions, current live transactions, do not have a problem with the BVN because they would certainly would have complied with the BVN. You are dealing with Nigerians who may not have legal resident status where they are and therefore cannot easily come back home. Are not in a position to go to financial institutions in those locations to try to update their records in Nigeria. So that's the class of people that we are worried about. And for me, I do not think they account for a large pool of the funds coming through the official channel. Their monies come to Nigeria. You have diaspora remittances to their family members, but they normally go through the unofficial channels. But the funds coming from the official channels, like when the government said they want to raise the diaspora bond, that category of investors will not have issues with the BVN challenges. For me, the concerns are as it relates to fairness and equity. Would it be fair and equitable to take the money of an individual who has small balances with the bank just because he has not complied with one of the requirements of account opening? If you go to the Money Laundering Act 2011, Money Laundering Prohibition Act of 2011, what it stipulates that the accounts will be frozen. It never, I've gone through it and I didn't see any point where you say the monies will be appropriated by the federal government. So appropriation involves attack on individual property rights, unless the government has proven that those balances relate to process of criminal activities. Well,
we have seen the court order, and of course a lot of people think it's not right. So where do we go from here? Where can the CBN come into this?
You see, unfortunately, the CBN is one of the defendants to the case. And interestingly, this is what they call the federal government want to score a goal without a penalty without a goalkeeper. The banks are not in a position to go as applicants at the higher court to contest this court order. The central bank...
But all the banks are the respondents.
All the banks are respondents, but they do not have overwhelming interest to contest the order. So you are dealing with... And then the poor people in the rural areas, the beneficiaries of deceased account holders, the Nigerians in diaspora that are living in countries where they can't easily come back home, do not have, none of them have the capacity to contest this action. Anybody who has the capacity to contest this action will only go to the bank and regularize it. So you're going to deal with a case that only the government can come back and say, let's vary this order, court order. It's a Minister of Justice that we should appeal to go and vary that order and allow time or segment the accounts so that we are focusing on accounts that are suspicious transactions.
Well, let's just hope that someone will come up and make such an appeal. Thank you very much for your time.
My pleasure.
Right, Johnson Chukwu is the Managing Director, Cowrie Assets Management Limited. We'll take a break, and when we come back, we'll take a peep into the equities market today.